Put simply, administrative acts are binding or constraining edicts that come not through law, but along other pathways. For example, when an agency issues a rule constraining Americans, barring types of pollution or perhaps land use, this is an attempt to exercise binding legislative power not through an act of Congress, but through an administrative edict. And similarly, when an agency adjudicates an administrative violation, let's say imposing a fine or some other penalty, this is an attempt to exercise binding judicial power, not through a judicial act, but again through an administrative edict. Now leave aside for a moment whether these administrative edicts are unlawful. What makes them administrative is that they bind Americans not through law, nor through the decisions of courts of law, but through other mechanisms. So you can think of administrative power as, well, off-road driving, right? The Constitution generally authorizes two avenues of binding power, acts of Congress and acts of the courts. But the executive prefers to drive off-road, not through statutes and judicial acts, but along other administrative paths. And for those in the driver's seat, this off-road driving is exhilarating. For the rest of us, however, it's a little unnerving. This understanding of administrative power in terms of binding edicts excludes, note, lots of executive action. So when I complain about administrative law, my complaint is not about government benefits or privileges. It's not about welfare or social security. And the complaint is not about orders to officers within their executive authority, for example, in distributing welfare. There could be problems there. This is not what this is about. Instead, the administrative law problem consists of attempts to bind or constrain Americans legislatively or judicially through acts other than those of Congress and the courts. On this understanding of administrative power, administrative law is a constitutional puzzle. Now, of course, our government is full of puzzles, and perhaps more so with every decade as we get more and more decisions from the courts, not to blame anyone in particular, but none of these puzzles are as serious as administrative power. The immediate puzzle is that administrative power does not match the powers authorized by the Constitution. The Constitution, of course, authorizes three types of power: legislative power in Congress, executive power in the president and its subordinates, and judicial power in the courts. What then is administrative power? Is it a fourth sort of power? It's often said so by some of my colleagues. But then how is it constitutional? My talk today will lay out two possible answers, both framed in terms of history. The first, conventional and rather sunny view of the history, is that administrative law is a modern development. This conventional vision emphasizes the modernity of it all. There are many doctrinal justifications of administrative power, and we can talk about them later. My book goes into considerable detail about them. But the foundational justification is that administrative power is modern or novel, and so it's without much depth of history. From this perspective, administrative power begins around 1887, when Congress creates the Interstate Commerce Commission. Administrative power then repeatedly expands every several decades, in the early 1900s, the 1930s, 1970s, and again now. A variant of this conventional sunny view comes from Jerry Mashaw at Yale, who suggests that administrative power began to develop a little earlier in the early practices of the federal government. But even this maintains the gist of the standard version, which is that at some point or another, after the founding of the Constitution, we get administrative power. Whether the conventional vision begins in the 1790s or the 1880s, the argument is that it developed since 1789 as a pragmatic response to the practical problems of American life. Sounds very reassuring, right? And although not mentioned in the Constitution, administrative law allegedly was, and these are quotations from Landis, an indigenous and empirical growth, which necessarily arose to deal with, again, our practical, pragmatic realities of American life. The conventional vision thus becomes an apology for administrative power. Sociologically, the message is one of modernity and necessity. Administrative law is a modern type of power necessary to handle the complexity of modern society, and so it's anti-modern and quixotic to resist it. I guess that makes me anti-modern and quixotic, but I guess that's not news either, is it? Constitutionally, the message is that administrative law developed after the adoption of the Constitution, and so it could not have been anticipated by the Constitution. And therefore, even if it's not amongst the powers authorized by it, it's a necessary and modern addition. Again, a reassuring story, if you believe it. The justificatory implications are very powerful. In this conventional vision of the history, post-constitutional necessities just slice through the tripart division of powers in the Constitution. In the standard vision, pragmatic necessity for the executive to exercise all powers of government allows it to combine legislative, judicial, and executive power. In this pragmatic vision, moreover, well, you don't really need judges and juries, right? Just have the executive decide. Indeed, an agency can be a prosecutor, judge, and jury. And in the standard vision, pragmatic necessity avoids the need for all of the procedural rights guaranteed in the Bill of Rights, on the theory that it all can be reduced to administrative process, or as the line goes, this is all the process that is due. You get out of court and suddenly you don't need due process, and so forth. But there are problems with this conventional vision, and the most basic question concerns its historical accuracy. Is it true that administrative law is modern, post-constitutional American development? Is it true that the Constitution could not have anticipated administrative law and therefore did not prohibit it? Ultimately, the conventional vision doesn't dig deep enough, I think. It is a cheerful, breezy vision of history in which the past is not examined very closely in all its sweetness and light. So, let's turn to a second vision of the history, which looks below the surface of the usual apologetics and points, I think, to a dark and very dangerous past. In fact, administrative power revives absolute power. Rather than a modern necessity, it is a version of a recurring threat, one inherent in human nature and the temptations of power. The constitutional history of the last 1,000 years records the repeated ebb and flow of absolutism on the one side and of law on the other. And there always have been pressures for the absolutism, and law only sometimes has been able to resist. So during the next 10 minutes, let's examine the history of absolute power. And as I recount it, please think about the modern parallels. I may be talking about medieval or 17th century English history and their kings, but you should be thinking about contemporary presidents. We need to begin with prerogative power. English kings were widely expected to rule through law. They had parliament for making law and courts of law for adjudicating cases. And kings were expected to govern through the acts of these bodies. Thus, to bind their subjects in general, they had to seek acts of parliament, and to bind their subjects in particular cases, they had to seek the acts of law courts. But kings, of course, were often discontent with governing through law. They wanted control, more control than they could get when relying on their legislature and judicial acts. And so they therefore often acted on their own, not through law, but through royal or prerogative power. The power ordinarily exercised through law thus was evaded when kings acted through prerogative power. Prerogative power thus was, you could say, the predecessor of administrative power. Prerogative power was the personal power of kings. Administrative power is the bureaucratized power of the state. But otherwise, they're very similar. Both have been evasions of law. Consider these prerogative evasions, and they should sound familiar if you know anything about administrative evasions. Ordinarily, kings bound their subjects through statutes, but with their prerogative power, they bound them through proclamations or decrees, what we call rules and regulations. Ordinarily, kings repealed old statutes by obtaining new statutes, but through their prerogative power, they issued prerogative dispensations and suspensions, what we call waivers. Ordinarily, kings could enforce law only through the courts of law, but with prerogative power, they enforced their extra-legal commands in their own prerogative courts, King's Council, Star Chamber, High Commission. We have the equivalent of these. They're called our administrative agencies. Ordinarily, the kings had to work through courts of law with the due process of law. But in their prerogative courts, they could use civilian inquisitorial process, what we call administrative process. Ordinarily, kings resolved disputes about royal power. Ordinarily the judges resolved disputes about royal power, but on account of the prerogative power, kings expected deference from the judges. They expected deference to prerogative regulations, to prerogative interpretations of statutes, and to prerogative fact-finding. And interestingly, though, unlike today, the judges then generally refused to defer. Last but not least, prerogative power evaded English divisions of power. Although the English did not yet have a full separation of powers, they had a basic division of powers. Parliament made law, the courts adjudicated it, the king exercised force. Nonetheless, when kings act through their prerogative power, they or the prerogative courts exercise all government powers. For example, the Star Chamber made regulations, prosecuted infractions, and adjudicated them. It sounds just like a modern agency. Evidently, prerogative power was a means of evading government through law. It was a way of exercising it outside the law. And just as kings evaded law with prerogative power, the executive now evades law with administrative power.
Welcome in, welcome in. Thank you for joining me tonight. I want to talk really briefly about that video and how he was breaking down how administrative courts are unconstitutional. I also want to go over this document really quick. And if you want a copy of this document by Judge Dale, which is a retired judge, really whistleblowing the whole system about how the courts are really false and unconstitutional, just send me an email at divinetrustbaby07@gmail.com and I'll get it over to you. Make sure that you're specific when you are requesting this in the subject line of that email so I can know exactly what you're talking about. Because some people, because I have so many videos and I say that I'm going to give stuff out for free, sometimes it's a little confusing when you guys come and request certain things because I'm like, I don't know what you're talking about because I have so many videos where I say I'm going to give out documents for free. So be specific and request that the specific document that you want. But this is a 92-page document that is written by a retired Judge Dale, who is whistleblowing everything about the court system. It's called The Great American Adventure, Secrets of America, Political History of Government and Law. And it includes all the important must-read Bankruptcy of America on 1933 on page 36. Please note, images were not part of the original work and formatting has been slightly altered to reduce eye strain. Okay, so I'm just going to read through this first page. And then, like I said, if you want a copy of it, just send me an email and say in the subject line, Judge Dale document. And then I'll know what you're requesting and I'll send it over to you as soon as I can. But let's get into it. The Great American Adventure, Part 1, A Lesson in Fraud. Due to an historic perversion and expert mind programming labeled as Babylonian slave driving techniques, which has been adopted and employed by the United States government, few citizens realize that America is not what they perceived it to be. Elephants are gray, but not all gray things are elephants. The expose hopes to reveal to you the great adventure and some secrets of America, but not all because there are too many, such as America is not a free or constitutional country. Factually, it isn't even a country. America is a privately owned French corporation, and its motive of operation, known as politics, government, courts, laws, currency, and commerce, are merely the byproducts of several greedy, vivid, and intellectual imaginations belonging to the royal and elite of Europe, and controlled with the aid of their foreign agents and slave drivers who act in America under the protection of the Foreign Sovereign Immunities Act. The success of this private corporation relies heavily upon the ability of its slave drivers, identified as the chiefs of staff, politicians, bankers, judges, priests, and lawyers, to convince teachers, policemen, soldiers, and the general public of its authenticity. Two major problems exist for this private corporation because everything that the corporate board of directors, the European royal elite, and the Sabbatean Jewish bankers decide is always recorded somewhere and is accessible with the advent of new technological advances. Even some of those files marked top secret are accessible with a little help from your friends. Ironically, the only secrets being concealed within those files is their treason, rogues history, and new technological advances being withheld from public view. History is a fable agreed upon, Napoleon Bonaparte. Would it interest you to know that historically every documented skirmish, global catastrophe, and war that ever occurred on Earth since ancient Babylon has been a well-planned and staged event orchestrated by the royal and elite classes of the world with a focus on mind, crowd, population control, and the stimulation of commerce? After all, the European Board of Directors makes their money off of commerce, and unfortunately, wars and catastrophes generate more income and spending than tranquility and peace. Do they care that people might die? Like all sociopaths, they actually plan on it. What would be your first reaction if I were to prove to you that 2 elected presidents of the United States were never American citizens and were elected under an alias or assumed name? The first name was a German national. The first man, was a German national, an atheist, and former Nazi SS naval officer, and the former director of the Nazi intelligence agency called Odessa. The second man was a South African national and is a Marxist, a racist, and anti-Christian. This is disparaging. This is a disparaging fact to hear or read about, especially since colonial America was founded by Christian people seeking freedom from religious persecution. People who just wanted to be left alone, which made them as easy mark for unscrupulous men. That's false. So everything in this document is not completely true. However, we're going to only focus on where he's breaking down the court system because he's actually being 100% honest. Some of this stuff is his own uh opinions, basically, because everything that someone says is not always going to be true. However, I need you guys to have the mind and intelligence enough to know, what you're going to take and what you're going to leave behind. And I hope that makes sense. So let's jump straight into tonight's presentation. Without further ado, we're going to be talking about declining to appear and strategies for court. I'm going to be giving you guys actual strategies that I've actually used myself, especially when it comes to traffic citations. I don't know how many times I have shared this. It's really easy to do, especially outside of the courtroom, but stay tuned and really take notes and pay attention. Watch this video as many times as you have to, but this will help you to get out of traffic citations and, even having to appear in court for different things. Because once you appear in court, you are the debtor. Okay? So declining to appear and strategies for court. Disclaimer, the information presented in this presentation does not belong to me. I am not the creator of it and I do not own it in any way. I'm a private being that has studied various United States laws, codes, statutes, and Admiralty maritime jurisdiction. I am not and never would be a lawyer, legal aid, or attorney. This is not legal advice, but it is lawful. I have executed many processes for myself. The info included in this presentation should be fact-checked before executing anything. Anything you execute is at your own risk and that alone. Studying and learning as much as you can about this process is advised because the more you know, the more you grow. Let's get into it. Oh yeah, but before we begin, please hit that like button to help this video be recognized in YouTube's algorithm so that it can be displayed to more people. If you haven't subscribed, hit the subscribe button as well. I appreciate your support, and by simply taking those actions, you support my content and it helps me to continue making these videos to help others. So if you like my content, if you like what I'm providing, and you would like me to continue doing this by giving this information out for free for those who might not be able to join my private community so that you can independently learn and do this and helping you to get closer to your freedom, then please just do those 2 little things for me. Subscribe and hit the like button, share this video, comment, do whatever it is that you can to help this, because you don't always got to help by giving donations, right? You can help by helping this channel grow. You sharing it with one person is a lot, okay? So let's get straight into it. Declining to appear. An administrative court is a dispute resolution service for consenting parties. A summons is an invitation, summoning or calling you to accept their dispute resolution service in Admiralty maritime jurisdiction. So, of course, you have the right to decline their offer of contract. Since jurisdiction is attached to the artificial legal person name, all caps name, not the living man or woman, it is essential to correct the mistake in the matter of the name as soon as possible after a summons is received. It is not necessary to go to their court. Indeed, by simply making an appearance in their court, you will imply your belief in the person, which is guilty by default since it is a debtor in surety for the corporate national debt. If you appear in their court theater, they will presume that you are acting in joinder to an artificial legal person under the court's jurisdiction because you are there. So showing up in their courtroom is your consent, regardless, okay? Maxim of the law, the court has nothing to do with what is not before it. So if nothing has happened in front of that court has nothing to do with it. There is no reason for you to show up. There is no reason for you to assume liability, okay? Alternatively, the notice of conditional acceptance, subject notice to appear, can be sent to the registrar of the court to decline their offer. This usually cancels out the hearing, as there is no joinder and no proof of claim. It's just an allegation or hearsay. The registrar of the court accepts and stamps court documents. You can require a copy by return post for your records. You can even go to the registrar's office, and if they refuse to make you a copy, you can take documents, copy them, then return the originals. So this is an example of notice of conditional acceptance. This is how you would draft this, okay? So this is giving you guys an idea of how to do this so that you can decline by conditional acceptance. You will not appear in their courtroom. So it reads, notice of conditional acceptance, which stands for subject notice to appear. I, a man or woman, refer to the attached notice dated, and you will put the date, and advise that you offer to assume jurisdiction and your instrument have been accepted for value and consideration upon proof of claim and returned without dishonor within 72 hours for and on behalf of, and then you would put your all caps name followed by TM, which stands for trademark, by, and then you will put your beneficiary signature. So John Henry Doe, and a red fingerprint, which stands for a living, okay? Underneath of that, you would put your same beneficiary signature, John Henry of the family Doe, comma, principal creditor, okay? And then you will write, all rights reserved without prejudice, waiving none ever, in my true, lawful, and private capacity as beneficiary of the original inherent jurisdiction. Consent must be sought in all matters of privity where mutuality of interest occurs, okay? So if you have a pending court date, you've been summoned to go into their courtroom, you will send this out, okay? And again, I'm going to read it. This can be sent to the registrar of the court to decline their offer. So the clerk of the court, the justice of the peace, you can send that to those people, okay? And again, this usually cancels out the hearing, as there is no joinder and no proof of claim. It's just an allegation or hearsay. The registrar of the court accepts and stamps court documents. You can require a copy by return post for your records. You can even go to the registrar's office, and if they refuse to make you a copy, you can take documents, copy them, then return the originals, okay? So let's get into strategies for court. This is a picture. It's very blurry, but this is the best picture that I could get of retired Judge Dale. That's the document that I was reading from at the beginning. He wrote that document to basically let everyone know that the courts are corrupt and they're only out to collect, okay? So he said, avoid their courts whenever possible. So why would you go into their arena and play ball with them? Because the ball is not in your court, especially if you lack this knowledge, okay? So America's courts, all administrative courts and admiralty jurisdiction are pseudo courts or fictions and simply are corporate administrative offices designed to resemble courts. And all of their judges are simply executive administrators designed to resemble judges, okay? The purpose of these pseudo-corporate courts is only to settle contract disputes, and since George Washington's government was military in structure, if either party refuses to participate, these courts cannot become involved, and the dispute is dead in the water, okay? My use of the term dead in the water is not a canard because these pseudo courts are unconstitutional courts of admiralty, the international law of the sea. Everything was created on war, including the American flag. That is a war flag, okay? Inside of the courtroom, those flags have yellow fringes on them, which cancels that flag out. So that courtroom has a false flag hanging, a false war flag hanging. And you go into their false fictitious courtroom and you play in theater. You are acting in commerce, okay? You're an actor, and so are those judges who are really executive administrators, okay? All of it is fiction. And when you go in there, you become the fiction all cap name, okay? The pseudo judges of these pseudo courts have no powers without the consent of both the plaintiff and the defendant. And in every case, the judge must determine that he has consensual personam and subject matter jurisdiction before he can act or access the SKV trust. Okay? Note, all tradable securities must be assigned a CUSIP number before they can be offered to investors. Birth certificates and social security applications are converted into government securities, assigned a CUSIP number, grouped into lots, and then they are marked as a mutual fund investment. Upon maturity, which is 30 years, The profits are moved into a government SKV trust, and if you are still alive, the certified documents are reinvested. It is the funds contained in the SKV trust that the judge, clerk, and county prosecutor are really after or interested in. This trust actually pays all your debts, but nobody tells you that because the elite consider those assets to be their property, and the Federal Reserve System is responsible for the management of those investments. So their guise is just to get you to go into joinder so that they can take what they gave you at time of birth, okay? They only want to access that. Social Security, SSI, SSDI, Medicare, and Medicaid are all financed by that trust. So like I said, when you get government benefits, they're taking from your trust and giving it to you. That's why you have to fill out an application, because they want to securitize that application so that they can go into that trust with your permission and give you what belongs to you in allotments. And the funny part about it is they create eligibility standards so that if you do get denied, they still have access through that application that you filled out and signed, giving them permission to go inside of it. It becomes a trust contract. Okay. And so even if you get denied based off of their eligibility standards, they're still taking what they want to take from it, regardless of you being denied or not. So this is why it's a loophole to everything, like the lawyers that are bar association members would say, because it really is. Okay. The government makes you pay taxes and a portion of your wages supposedly to pay for these services, which they can borrow at any time for any reason, since they cannot access the SKV trust to finance their wars or to bail out Wall Street and their patron corporations. At your arraignment or trial, the judge will ask you if you are the named individual, which is the all caps birth name on the complaint. And your natural response will be to answer in the affirmative, but that is exactly what they want you to do. They want you to say, yes, I am John Henry Doe. Yes, I am Jane Mary Doe. They want you to say that, okay? Remove your birth certificate and respond to him by stating, I am making a special limited appearance on behalf of the defendant who is right here, and hold up your birth certificate. Then state the following. As I understand this process, Judge, the county attorney or police officer has leveled a criminal charge with the clerk against the trust, using the all caps name that appears on this birth certificate. The use of capital letters is dictated by the United States Printing Style Manual, which explains how to identify a corporation. The clerk, who is the administrator of this SKV trust, then appointed you, Judge, as the trustee for the trust, and since neither of you can be the beneficiary, that leaves me, and therefore you are my trustee. So as my trustee, I instruct you to discharge this entire matter with prejudice and award the penalties for these crimes to be paid to me in compensation and damages for my false arrest. Okay? That is very helpful for you guys if you are facing court, or if you already have to show up or whatever. You will know how to handle this, but you have to know this and you have to do it with confidence. Note, the law of trust dictates that an administrator, trustee, and beneficiary cannot serve two positions in a trust. So a trustee cannot be a beneficiary too. Okay, so that judge cannot play your role. He's appointed as the trustee. But when you take responsibility and go in there as the debtor all caps name, they become the beneficiary and you become the trustee, which means you owe the debt. Okay, and that's when you pay it in debt notes, and they go inside of your SKV trust and take what they really want. Okay. The trustee judge has no alternative but to honor your demands, but you have to get this right and act with confidence. You really need to know this information well so that you can't be hoodwinked or confused by either of them. They will or may attempt to play some mind games with you if you display any doubt, stammer, or display a lack of confidence. Appearances, the pomp and majesty of these pseudo courts is totally for your benefit and is intended to invoke fear and intimidation. If you show fear or intimidation, you get a pony ride. Okay? If the county attorney begins to act too cocky with you, you can take the wind out of his sails by asking him to produce the 1040 for this case. If he denies the need to do such a thing, inform him that you will be taking care of it for him as soon as possible. He may move for a discharge at that point because you are a little too dangerous or smart. The last thing that prosecutor wants is the IRS examining his files for the last 7 years because he makes money on every conviction, but he doesn't pay taxes on them as a rule. He usually only declares the salary he receives. Okay, keep that in mind. That's why they're in the Bar Association. It's like a private membership for those who know secrets and keep those secrets within. Okay, it's a brotherhood. Now let's talk about citations, because I know a lot of people were asking me about citations, and this is the most effective way, to be honest, other than what I teach in one of my courses about it. And I have proof to show that I've done it. But I've done this and I've done the other method. It's more than one way to skin a cat. So I've done two different methods that work perfectly to get these citations dismissed without even having to show up in the courtroom. Okay. So the citation process can be handled much easier through the mail. I can personally attest to this, as I've had several citations dismissed through mail. When a police officer issues you a citation, he is actually requesting you to contract with him. He is alleging that you violated a corporate regulation in writing, which you have accepted by signing, and thus requires you to respond. So, as I always tell you guys, you don't have to sign it. You can just write UCC 1-308 on that ticket. Or you can get a UCC stamp. And if you are interested in getting that, I'll tell you how to get it later on. But you can stamp that way. You don't have, or you can write your beneficiary signature and then UCC 1-308, or you can write under the rest. Anything that has under the rest on it is automatically thrown out because it cannot be processed. Okay. It means that it's under force. Anything under force can't be processed, but UCC 1-308. And then the police officer is instructed to explain that your signature is merely an acknowledgement that you received a copy of the citation, but in actuality, your signature is notification to the court and judge that you have accepted or consented to this offer to contract, which also grants the judge consent, personam, and subject matter jurisdiction over you and the case. And that's what you don't want. That's why you don't sign your name as a signature. Never do that. You can cancel that contract, however, by rescinding your consent, excuse me. The Federal Truth in Lending Act provides that any party to a contract may rescind his consent within 3 business days of entering into such a contract. So across the face of the citation, you should print or type in large print the following words: I do not accept this offer to contract, and I do not consent to these proceedings. You will do that on that citation that officer gave you, and you will make copies of it, okay? You will write it in blue or red ink. Use purple, excuse me. Use blue ink for Admiralty or purple ink for royalty, okay? Admiralty is the court and royalty represents your sovereignty. Either way is appropriate. Sign your signature underneath in blue or purple ink and in front of a notary, and under your signature type, you're going to write, without prejudice, UCC 1-308. This is another way to declare that you may not be held responsible for this contract pursuant to the Uniform Commercial Code. Serve cancel citation back on the clerk/court, along with a certificate of service by certified mail, return receipt requested. This kills the citation, removes your consent, and removes the jurisdiction of the court, all at the same time. It is really that simple. Like I said, I've done this several times, so it really is simple, okay? Note, a certificate of service is a letter that first identifies the citation and then defines how and when you return the document to the court and is signed. If not denied, it becomes a truth in commerce by tacit procuration. Remember to keep a copy of everything in case the clerk attempts to trash your response, which sometimes they do, and you got to send it back again, but it's very rare that that's going to happen. It happened only one time with me, which certainly will not happen with a certificate of service or if it is mailed back by the notary. The notary is actually a deputy secretary of state and is more powerful than the court clerk, okay? This is how you're going to deal with summons and lawsuits. The summons process, whether it is defined a civil or criminal action, is once again an offer to contract, despite what words are used to command your appearance or response. It too can be canceled just by following the same procedure as the citation process above. $1 million lawsuit is no different than a citation, and both can be canceled. Hard to believe, isn't it? And that comes from retired judge and whistleblower Judge Dale. Again, that document, if you want it, you can email me at divinetrustbaby07@gmail.com and I'll get it over to you. Again, I'm going to say it again. If you'd like a copy of the 92-page document that retired Judge Dale wrote, whistleblowing all the truths about the courts and how they bank on our ignorance, email me at divinetrustbaby07@gmail.com to request a copy. Please be specific in the subject of the email. Literally type requesting Judge Dale document. I believe this document will be very helpful for anyone who wants to further comprehend how the courts operate. It will help you act accordingly whenever you have to go to court, or how to deal with it without even going to court, okay? And you don't want to step into their courtroom, but in the event that you have to, you will know how to handle and conduct yourself, okay, in your affairs. Establishing your living standing in court. There are times when a living man or woman finds themselves in a court before a judge, either unwittingly or by force, despite not giving their consent, and without having caused injury to any living man or woman. Although an administrative court, no jury, is a dispute resolution service for consenting parties, which are living men and women who consent to joinder with dead legal persons, it is also a place of ancient satanic magic. This is why living people are summoned as if to magically appear in court, becoming dead, right? Historically, a judge wearing a black robe is a high priest of Baal in the temple of Baal, enforcing Babylonian Talmudic law, The judge or the black robe devil requires an offering from those who appear in the temple. The priest of Baal makes a judgment upon the one who has given up their life, and in doing so, the priest delivers a curse, in ancient times death, in modern times debt, and or a sentence, and the victim is sacrificed. The word bailiff derives from Baal, because the bailiff is the servant of the high priest of Baal. The Black's Law Dictionary in this context is a book of black magic. Why do you think it's called Black's Law? Dead law, okay? However, if you do not wish to be presumed dead, suffering judgment, you must establish your living rights. Otherwise, you will simply have no rights, okay? Maxim of the law. One who does not establish their rights has none. I tell you guys this all the time. I say it in different ways, but this is very important. They're not going to tell you this, and they're not going to do it for you. So you have to do it. You have to be knowledgeable enough to establish those rights so that you can stand on them. To establish your living standing in court, you want to first, this is what you want to say: Your Honor, I am a living being. I humbly ask for a remedy. At this point, if you have behaved with honor and respect, which you should, you may be dismissed. But the judge is not out of options. He can leave the court and re-enter, now in a higher court, under canon admiralty maritime jurisdiction. So you must establish your standing again, but in a higher manner. 2, you're going to say, Your Honor, I am a living being. The flesh lives and blood flows. Your Honor, I humbly ask for the cure and maintenance. The judge may be totally freaked out at this point. If he doesn't dismiss you and decides to leave again, he comes back as a priest. So you are in a temple now, and the court is under Talmudic law, which is very rare indeed, because the judge is at that limit of his authority and vulnerable. So you must establish your living standing appropriately by addressing him as follows. 3, you're going to say, Your Honor, I wish to establish that I am a living being. The flesh lives and the blood flows, and we are sovereign, and nothing stands between myself and the divine. And that's it. The game is over. You control the court and can dismiss the judge. When the judge leaves, you can leave. Once the judge leaves, it's over. Now, 1 is UCC. That's the power of fine, okay? 2nd is Admiralty Maritime, which is the power of jail. And 3 is Talmudic, which is the power of death. The Talmud is a book that they consider holy. The Jewish people, who are mostly lawyers and judges, who are pretty much the creators of all of this. Let's be real. They are the bankers. They are the court system. They are the the religious structure and how things are ran in this, and they do things very ritualistic. Okay, so understanding that will help you out a lot. Let's talk about Uniform Commercial Code, also known as UCC. The administrative courts are administering the international bankruptcy, and therefore they operate in the International Admiralty Maritime Commercial Jurisdiction, which is the law of the sea, and are bound by the Uniform Commercial Code, UCC. The UCC is a colorable version of admiralty. Colorable admiralty jurisdiction is known as statutory jurisdiction. Color of law, mere semblance of a legal right. State example rel. West versus Des Moines, 96 Iowa, 521-65 Northwest 818. That's where that comes from, okay? That's the actual court case if you guys want to look it up. In order for the UCC to be implemented, there had to be a provision requiring it to be in harmony with the common law. This requirement may be found at UCC Section 1103, which, when invoked along with UCC Section 1207, which is now UCC Section 1308. So 1308 used to be 1207. Okay, so if you see 1207, they're talking about 1308. And it represents a powerful method of protecting your natural rights from encroachment by the government. And this is why you want to use that as much as you have to on all contracts, all applications. You want to reserve your rights and use that Uniform Commercial Code. Okay. The recourse appears in the Uniform Commercial Code at 103.6, which says the code is complementary to the common law, which remains in force, except where displaced by the code. A statute should be construed in harmony with the common law unless there is a clear legislative intent to abrogate the common law. Again, that's UCC 1-103.6. This is a strategy we use in court. The code recognizes the common law. If it did not recognize the common law, the government would have had to admit that the corporate state is bankrupt and is completely owned by the creditor or its creditors. But it is not expedient to admit this. So the code was written so as not to abolish the common law entirely. Therefore, if you have made a sufficient, timely, and explicit reservation of your rights at 1207, which is now 1-308, you may then insist that the statutes be construed in harmony with the common law. And this is why you want to use that, okay? If the charge is a traffic ticket, you may be deemed that the court produce the injured person who has filed a verified complaint. If, for example, you were charged with failure to buckle your seatbelt, you may ask the court, who was injured as a result of your failure to buckle up? However, if the judge won't listen to you and just moves ahead with the case, then you will want to read to him the last sentence of 103.6, which states, the code cannot be read to preclude a common law section. Okay, tell the judge, Your Honor, I can sue you under the common law for violating my rights under the Uniform Commercial Code. I have a remedy under the UCC to reserve my rights under the common law. I have exercised the remedy, and now you must construe this statute in harmony with the common law. To be in harmony with the common law, you must come forth with the damaged party. If the judge insists on proceeding with the case, just act confused and ask this question. Let me see if I understand, Your Honor. Has this court made a legal determination that sections 1-207, which is now 1-308, and 1-103 of the Uniform Commercial Code, which is the system of law you are operating under, are not valid law before this court? Now the judge is in a jam. How can the court throw out one part of the code and uphold another? If he answers yes, then you say, I put this court on notice that I am appealing your legal determination. Of course, the higher court will uphold the code on appeal. The judge knows this, so once again, you have boxed him into a corner. And that's what you want to do. You guys want to play a game with me? I'm going to play a game with you guys and let you guys know that I fully comprehend this process and I know how to enforce and stand on my rights. That throws them for a loop because they're not used to that. The quick four sentence method, okay? This is another one. This method, according to multiple sources, was used by a woman in Los Angeles at an initial appearance in an administrative court where there was no jury and no injured party to close the books on the charge. When you close the case, they leave you alone. The first sentence expressly declines consent. This prevents the presumption of consent. The second sentence declines the offer to contract. An administrative court is a dispute resolution service by contract. The third sentence declines to become surety via the artificial legal person named debtor in the debt money system. And the fourth system demands a bond against harm, which court officials hold insurance bonds, which can be called upon to indemnify anyone they may damage. Okay, so the first sentence is, I do not consent to these proceedings. The second sentence is, your offer is not accepted. The third sentence is, I do not consent to being surety for this case and these proceedings. And the fourth is, I demand the bond be immediately brought forward so I can see who will indemnify me if I am damaged. Okay? You're just going to play them games with them. At this point, the judge reportedly dismissed the case and told her to leave the court. Someone observing this method repeated it and was also released. After the second, you hear this, guys? All you have to do is enforce your rights by not consenting. Okay? It's really that simple. And this can be criminal or civil. Okay? Where am I? After the second case, the judge told everyone to go home and close the court for the day, leaving the court. If court officials expect someone to use this method, they will typically reschedule the case to the end of the day so that others will not see this. Judges do not want this method known, and bar attorneys will not and cannot do this for you. If you enter their court intending to do this, you must do it yourself as soon as possible. So you don't need a attorney, lawyer, legal aid. You don't need any of those what they call public defender. You don't need them to do this because they're not going to do this for you. Their job is to get you to pay, even if it's a small amount or even if it's for you to take some type of plea deal or anything like that. That is what they're in there for. They know these loopholes. Like I said, they're the ones that said there's a loophole to everything, but they're in an association that does not allow them to be honest, basically. Okay? Do not let them distract and dissuade you, because if you agree to engage in any issue they attempt to raise, you are consenting to their jurisdiction and you will lose. Keep it simple. Do not add anything. Say only the 4 sentences. If necessary, repeat it, repeat it, repeat it. Say it as many times as you have to. And memorize all 4 sentences or keep a copy, because you never know when you may need to use this. And I want you guys to know that I go live on YouTube every Wednesday at 5:30 p.m. Pacific time, 7:30 p.m. Central time, and 8:30 p.m. Eastern time. I ask you guys to please like, share, comment, subscribe, and turn on post notifications to be reminded whenever I go live, because the more engagement I get, the more I will share info for free about this process for those who may be unable to join my private community, and you can get this freedom all on your own. Help me help you. That's the least that I ask for. I'm not asking for any money. I'm not asking for any donations. I just ask you to like, share, comment, subscribe, and turn on post notifications. And tune into my lives if you can. If not, watch it at a later date. But help me to help you by keeping this information relevant so that it can help more people to free themselves from this corrupt system. Okay? I would also if you would like to email me, excuse me, if you would like me to email you free info to begin your studies independently, please email me at divinetrustbaby07@gmail.com to request the free info. I give out free information to anyone who requests it, so I'm not one of those gatekeepers who hold secrets and information. If you want to learn and you are willing to do your due diligence, I will point you in the direction. So if you want that free information, go ahead and email me at divinetrustbaby07@gmail.com. If you like how I teach and would like to learn more from me, consider joining my private community. Everything that you pay is a donation to keep it going. So the prices are very reasonable and very cost effective. Nothing is going to hurt your pockets. It's actually going to help you more than harm you. You can become a patron at patreon.com/divinetrustbabies. Or you can join DTB Academy for status correction. This is a status correction course where it teaches you every step of status correction and how to remove yourself from paying taxes at your job permanently by removing your election, and everything that you need to know step by step with instructions and examples, in a private Telegram group for only members of my academy and Patreon. Okay. And they do brainstorming Tuesdays. Every Tuesday they meet up and brainstorm together, and we have study sessions once or twice a month, every month, where we come together and we put this together even more. So it's a lot of support. And if you're one of those people who need that kind of support, then this might be a good option for you. Also, one thing I want to tell you, I do not hold hands. I'm looking for independent people. So you still have to do your due diligence. However, I provide everything for you where it is easy for you to do that in an environment that is easy for you to grow and learn. Okay. So if you're interested in joining the status correction course, that is divine-trust-babies.trainercentralsite.com/course/divine-trust-babies-academy. If you're interested in becoming a private banker and learning how to offset debts properly with the IRS and recoup abandoned funds, you can do that. You can join that at divine-trust-babies. My bad, guys. Let me get back into it. So if you want to join a private banking course, you can do that at divine-trust-babies trainercentral-site.com/course/foreign-trust-creation-discharge. Okay. If you're interested in accessing any of the past study sessions so that you can watch some of the study sessions, there are books and information there as well. You can sign up at divine-trust-babies.trainercentralsite.com/course/study-session-replays. Or if you just want to purchase content and courses and you want to do things independently, you can do so at linktr.ee.com/divine-trust-babies. And I want to thank you guys for watching. I appreciate your continued support, and I hope to see you guys next week. Have an abundant week. Thank you for being here.